Good afternoon, everyone. Thank you for joining me today for OSHA's Electronic Data Reporting Requirements Overview and Update. My name is Michael Metz-Topodas. I'm an attorney at Cohen, Seglias, Pallas, Greenell, and Furman in the Construction Litigation Group. Just a few preliminary notes as we get started here. The slides for today's webinar are available in the handout section and will be included in a follow-up email. In that email, you'll also receive a link to the recording for this webinar. Should you have any questions during the program, please ask them in the questions section of your GoToWebinar panel. I will address questions as they come up to the extent possible and as time allows. Certainly, we'll try to have some time at the end for any questions that people may have. As we get started here, I want to just take a moment to give an overview of what ground we will cover here. I've noticed that we have a number of both construction and non-construction people in the audience, so we'll try to balance the presentation to address everybody's interests and concerns and take the view of this topic from both perspectives. We'll take a moment to talk about the existing electronic reporting rule, which I'll go into in more detail, how that will also include the history behind that rule, and as well how it has evolved and some of the evolved over time, even as just its brief existence. As part of that discussion of the existing rule, there will also be discussion of the background and history of injury and illness workplace recording requirements all throughout OSHA. We'll then turn our attention to two pressing issues currently with respect to this electronic reporting rule, and that is a recent notice of proposed rulemaking and different enforcement initiatives that OSHA has undertaken. The official title of this rule that we're looking at is the Improved Tracking of Workplace Injuries and Illnesses. You can see the citation there for those of you inclined to look up the full text of the rule. Throughout this presentation, however, we'll just simply call it the Electronic Reporting Rule, as we've done already. This rule governs the electronic submission of data related to workplace injuries and illnesses. But it has its origin in hard copy records that I suspect many of you on the line are quite familiar with in terms of OSHA's requirements of recording such injuries and illnesses. Some of you who are safety and HR professionals are probably familiar with the 300, the 300A, and the 301. Just to make sure we're all on the same page and get everybody caught up, the 300 form refers to your log of work-related injuries and illnesses, and that is derived from individual incident reports that are prepared on Form 301. And then, as many of you know, at the end of the year, there is a requirement to prepare a summary of work-related injuries and illnesses, and some of you may know too that also Form 300A needs to be posted. But just as a refresher course, here is a look at the different forms. I suspect to many of you they look quite familiar. In addition to completing these forms, as many of you already know, they need to be maintained in hard copy in your records, available upon request, and are subject to a 5-year retention policy. The requirement to complete these forms pertains to businesses with 10 or more employees at any time during the calendar year. I raise that distinction because the rules for electronic reporting are slightly different with respect to numbers and also how those numbers are determined. But the important thing to remember, and the reason why we at least want to touch base on the prior rule, is that the electronic reporting rule does not in any way replace these requirements. Turning to the history of this rule, OSHA determined that with hard copy data, they struggled in its ability, to compile, access, and compare aggregate data to make assessments of safety issues in various industries. You can imagine that with only being able to access paper copies, to make any sort of analysis would require compiling it all electronically through some sort of manual submission or entering of data. There were then some initial forays earlier, 2010, 2014 period, where there was at least permission or permitted submission of electronic data from Form 300. Finally, in May of 2016, OSHA published the rule after a notice and comment period, and it went into effect January 1, 2017. Here's the final rule as written, and I say and I emphasize as written because shortly after it went into effect and the enforcement period sort of went underway, it became subject to changes. But at least let's get down the basics as to what it does say, and then we can talk more about how it evolved. But for establishments with 250 or more employees, the requirement demanded that they submit electronically data from all three of the forms we already looked at, 300, 300A, and the 301. There was an additional requirement for establishments, and I emphasize establishments, not businesses, and we'll talk about that in a second, that fell in the sort of 20 to 249 employee range, but were in a high-risk industry. Those employers and those employers with establishments that met those criteria needed to submit only the 300A data. And that high-risk industry group was published by OSHA on its website, and additional information listing all the different industries and businesses that fall into that category. The final rule pertains to establishments. And that's a very important point to emphasize here because it does not necessarily mean just a business. And we'll talk more about that in a second, but just to be very clear here too, covering the other scope of additional businesses, establishments with fewer than 20 employees have no obligation under this electronic reporting rule. And as well, as we talked about earlier, businesses with 10 or fewer employees throughout the year have no obligation to record workplace injuries or illnesses, at least not on the forms that we talked about earlier. So I just provide all these outline of information here just to give you an idea of the scope of the rule and what businesses and establishments are and are not affected. But the definition of establishment is what becomes critical for the enforcement of this rule. As defined by OSHA, essentially it is a single physical location where business is conducted or where services or operations are performed. Alternatively, it can be locations that supervise employees working in one or more physical location, or the base from which personnel carry out their work. That is derived from the definition in the regulations. And it's critical to understand that a business can have multiple establishments, each of which is responsible for complying with the electronic reporting rule. Because as you saw earlier in the definition or the outline of the requirements, it is based on the establishment, not upon the business. And so by way of example, establishments can refer to main or branch offices, terminals, stations, and it can even refer to individual construction sites or other similar off-site locations where a business is performing services or engaging in its work. However, they must be sites that are maintained for more than a year. So essentially, short-term sites do not qualify as establishments. Long-term sites will, and therefore the reporting requirements will apply to each of those establishments, including particular construction sites. And quite often, it's very rare that you'll have a project that does not get done within a year, unless it's somewhat on the small side. And so it's safe to say that for at least in the construction industry, any kind of long-term project will then in and of itself become an establishment subject to the electronic reporting rule. Now, that lays out what the requirement is. It would be a natural question, and I'm sure some of you already have it, with the exception of those who may have already done it, but okay, great. I have to submit data electronically. I have to do it from Form 300A. How does one go about doing that? OSHA has provided an online platform, and you can see that's the website right there. It should be a link when you get the final presentation, and you can click right to it. And we'll talk about what you see when you get to that link. But essentially, it provides employers two different ways to submit data. For those who deem it appropriate, you can manually submit data from each form. Arguably, that's probably not all that challenging because the 300A is a summary form. You can see it's just an outline of information. But if you have many different establishments, that process could arguably become cumbersome. But by and large, or be that as it may, there is a way for people to manually submit data right directly to OSHA. Some of you, however, might record and keep track of your 300, 301, and even 300A data electronically already. And by and large, there is a linkage between OSHA's website and some of those software that keep track of that data electronically, such that you can just do an automatic upload. And so if you have any uncertainty about whether your software is compatible with that, I suspect, as I understand it, as explained by those at OSHA, it should be generally compatible with most software that's being used in businesses these days. That said, if there's any concern about that, OSHA provides a trial platform. I said there for first-time users, but certainly anybody who wanted to test, I guess, first time for particular software. It is colloquially called the Sandbox, and that link that's provided there will also get you to that trial platform webpage. You'll see in a second it looks quite similar to the main page for online submission, but nothing that occurs there will be the actual submission. So it's a good way of testing out either how to do upload data or enter data manually, or to make sure that the automatic upload is viable as a way of submitting data. So this is just a screenshot of what you can expect to see from that initial page that was you saw on the prior website that'll direct you to initially submitting data. There's a little box, you might be able to see it where it says Launch ITA. Perhaps on your screen you can see now the cursor's there. There's a box that launches the website then to actually begin the uploading of data. And that's then this page. You can create an account, or if you already have one, obviously just do your proper login. I think we're all familiar with some of these processes for much that we do throughout our daily and business lives. And then this is what the Sandbox looks like. You can see that it's quite similar to what the actual login page looks like. And that's beneficial because it gives you an accurate representation as to what the actual submission of electronic data will be like. Having covered the mechanics, I do want to take a brief moment just to understand the why behind all of this. There are varying views about OSHA and its regulations. We've heard them all before, but I think what's important to understand is that there is a safety orientation here. And I think we want to talk about this rationale because I think it will be important to understand how this electronic reporting rule should be incorporated and folded into any business's approach to safety in general. Speaking to this rule in particular, before we get to that broad issue, OSHA implemented this particular regulation as a way of providing easily accessible and then manipulable industry-wide information. With that, they can use it to identify industry-wide safety issues. What does that mean? By collecting this data electronically and then having it searchable and usable in an electronic format, it's much easier than, and I'm sure we can all grasp this just from our own experiences, it's much easier than for OSHA to pinpoint particular and recurring safety issues. By way of example, if there's a particular tool that's causing certain types of injuries or associated with certain types of injuries, with the electronic data, OSHA then can combine and collect reports related to a particular injury, and then calculate or combine that information to perhaps address that particular safety issue, because you'll have data from all over the country that you can then assemble and use to determine if there's a common theme or a common thread as to what's going on. To the extent that the 300A is going to provide that information. There's another use for this information, and that is for business-to-business comparisons. with everybody submitting their 300A form data electronically, it does make it easy for OSHA and for perhaps others who can access the data to run comparisons about certain businesses within a particular industry, within a particular region. You can certainly understand that if all this information is represented on a spreadsheet or collected in some sort of database, all the particular filtering and data combination methods that we're all familiar with can be used in all kinds of different ways to run all kinds of different comparisons to assess how businesses match up with each other. As well, OSHA anticipated that this would create a race to the top. That with businesses' safety information put into the public realm, even on a summary level from the 300A form, that there would be an incentive for businesses to keep their safety, their commitment to safety and their public's information about their safety in the public, to keep that at the highest level. Because there would always be the potential of comparison to other businesses. And so it creates a motivation and an incentive for everybody to run their businesses as safely as possible. Finally, there is also, with the collection of electronic data, it's much easier for OSHA to conduct its own research. Again, I think this is drawing upon the first point as well, into all kinds of different issues with respect to how businesses are operating regarding injury and illnesses that are being reported. And so I offer all these rationale just to continue to remind people that OSHA's intention here is workplace safety. And what they look for to an employer is at least an embracing of that attitude, that safety becomes a paramount goal, without which no business can function or operate properly or effectively in a business context. And so what I encourage people as we start viewing and talking now about this rule and some of the enforcement and the implementation of it is to keep in mind that it's that safety concern that's most important, and that rationale and that mentality is what OSHA looks for with respect to how businesses, operate under its regulations. And so with any of the things we look for going forward, the purpose of the compliance is to comport with that commitment and attention to safety. Nonetheless, despite the rule's lofty intentions and despite the commitment to safety, there have been certain problems noted with the rule. In particular with the information that was to be disclosed. The discussion, you may have already noticed, is turning with greater attention to Form 300A and overlooking 300 and 301, and that's with the due intention. There initially was certainly criticisms about the rule that with all of those forms, all three of them, that there would be the disclosure of confidential proprietary business information. Safety events occurring at a business will necessarily require reporting and putting out in the public sphere, if it's electronically reported, information about how a business operates that could be deemed confidential or proprietary. As well, some took objection to OSHA's use of this information to, and quite literally that was their word, to shame certain businesses with their practices. And the concern was that you would create an unfair impression or unjustified conclusions based upon this publicly available 300A information, because there are many different circumstances where, although there might be an incident of injury or illness, it may not be the fault or anything to do with the employer. We are all probably familiar with certain defenses that can be raised with respect to citations, essentially where there's a problem, an incident that occurs. It very well might be that the business was just simply not at fault in any way. Nonetheless, by having those incidents reported, an outside observer might not know all the facts and might not know that the 3 or 4 incidents that are part of a 300A summary may not be a true indication of a business's commitment to safety, that same commitment we talked about earlier. The other problem, too, with Forms 300 and 301, as people have probably gathered, is that they provide in the public sphere personally identifiable information. And what OSHA determined is that there was no way that they could prevent that information from getting to the public. They would have to provide it in response to FOIA requests, and that any redaction of that information would not guarantee that it could protect any and all personally identifiable information, in that whatever remains unredacted could also give a hint as to what is redacted. So OSHA then took to some remedial measures shortly after the rule was passed. In the spring of 2018, they made a decision that they were going to do two things. One, prepare a notice of proposed rulemaking, and two, even while that notice was being prepared, not accept information from Forms 300 and 301. And so then finally in July of 2018, OSHA issued its notice of proposed rulemaking and essentially formalized this restriction on not accepting data from Forms 300 and 301. So right now, under the current regulatory scheme, only 300A data is required to be reported. The comment period has expired on the NPRM, and we're just waiting now for the final rule. As to the basis, there was an acknowledgement, just of the concerns that we talked about, that there was no guarantee that personally identifiable information would not make it out into the public. As well, there was acknowledgement by OSHA that they could be subject to greater security risks with having all this PII available. And essentially, it came down to just almost a cost-benefit analysis, in that there was negligible benefit from collecting the 300 and 301 data, and it was significantly outweighed by the harm that such disclosure of people's personal information could have. However, the current rule only addresses half the problem, arguably, in some people's minds. And I say this because there has been litigation out there trying to then address these other issues about the rule, and that is that there is still some business information available from the 300A. And the rule doesn't address this idea of shaming businesses and employers. And you still have a problem then as a result of unjustifiable conclusions that can have a dramatic effect on both sales and then recruiting. Sales, in that there are some people who would be reluctant to interact or do business with a company that might have a safety record that has certain injury and illnesses identified, or perhaps too many for some people's minds. And as well, workers might be turned off by seeing information from a 300A that might have incidents of injury and illness that particular worker might deem too high to be an acceptable place to work. And of course, as we talked about, none of those might be an accurate reflection as to what the actual safety conditions at a business might be. Turning now to the critical issue, especially for some of our compliance and other folks out there, is enforcement. And I think I offered a pithy slogan here some of you might recognize as to what the view of enforcement is for these regulations. And what we mean by this, do or do not, there is no try, what is meant is that it's a pretty straightforward regulatory scheme, at least the electronic reporting rule. Submit the data or don't submit the data. There really isn't much of a discretionary view or analysis on any of this. However, there has still been some flexibility, but that flexibility is diminishing. So I want to talk about that briefly in the time that we have left. First, the rule itself outlined a series of deadlines for submission of data. Interesting enough, yes, I have put the 2016 data submission. That deadline has long since passed, but you'll see why we have that just as more of a way of background, because it has something to do with the enforcement of the remaining deadlines. For those of you, for 2017 data, the deadline was about 6 months ago, back in July. And upcoming deadlines will be March 2nd of each successive year. And again, this is for only submitting electronically data from Form 300A. I include here just a few screenshots from different portions of OSHA's website. The first talks about a reminder of the July 1st deadline. And the second one is sort of OSHA's first foray on 2017 data as to enforcement. There's a note there, and some of you can probably see it in the bold, right before the bold print, that submissions after July 1st will be flagged as late, and therefore you can see now there's a greater emphasis on enforcing and holding people to these deadlines. This arose out of a concern of what happened in 2016. Of the 300,000 establishments or businesses or employers who were expected to provide electronic data with respect to injury and illness reporting, only about half complied. And even then, not all of them who did comply were within the deadline. Now, some of that may have arose due to confusion about which deadlines apply to which businesses. In particular, there was also confusion about whether there was an exemption for those states that had their own individual OSHA-related plans. But nonetheless, it is as a result of that low turnout that there was a greater turn towards enforcement. And that's taken a new twist here with what's called the SST-16 program. OSHA has a continuing program of site-specific targeting that is targeting certain businesses for inspection based on information that it receives and other criteria that it uses. But what it added to this program recently, and it became effective just recently in October of this year, was that those businesses that did not report their Form 300A data for 2016, of those, there would be a random sampling to identify and select certain establishments or businesses for inspection. The initiative does not apply in the construction industry, and particularly those with 20 or more employees. The initiative also identifies, interestingly enough, is that they will, for citing for failure to submit violations for 2016 data, inspectors will follow the interim enforcement procedures that were outlined earlier this year. And it's interesting to note how that all came about. So just turning back to the inspection procedures, notice the SST program is getting anybody who didn't submit for 2016 or a random sample. The inspection then says you apply this interim enforcement procedure. That was a memo that OSHA introduced in 2018, outlining an enforcement protocol, but it only pertained to 2016 data. So there's a question as to whether this memo still applies. But it would seem that the safest way to look at this is that because the 2018 memo here, if you can follow, incorporates this particular memo about 2016 data, that they're now applying it to 2017 data. So in other words, this memo outlined enforcement procedures. There are different consequences. We'll go over them in a second. I know we're running short on time. But there was a 6-month enforcement date of June 15th, which is 6 months after the December 15th deadline. I said before it was the December deadline was December 31st. There was a provisional extension, but the actual deadline was December 15th. And as you all know, there's a 6-month statute of limitations on OSHA violations. So it would seem that the memo would foreclose violations for 2016 data, but the procedures might be sort of reawoken with the incorporation of the SST-16, if you can follow all that confusing set of different memos. But that's the safest interpretation from a compliance perspective, is that yes, there still could be potential violations under this memo for 2017 data. So what does that all mean? Summarizing that memo before, there's 3 different types of misconduct and then remedial action that can occur. If you attempt to submit your data timely, but you encounter technical difficulties, as long as you provide notice to OSHA, there will be no citation. If you attempt to submit before the deadline, if you don't attempt to submit before the deadline, but you have your paper records and you provide them at an OSHA inspection, there will be an other than serious violation, but no penalty. If you did not attempt to submit at all and don't have the paper records, then there could be appropriate penalties. Turning quickly as to what those penalties could be, this provides an overview of all OSHA deadlines and penalties, but you can see the other than serious can be up to almost $13,000. Various businesses will take a different perspective on whether that fine is or is not a lot of money, but there are many other consequences that I want to go over very quickly that go beyond just the money here, because that's it is those consequences that I think that warrant additional and perhaps even heightened attention. If, for whatever reason, there is a failure to provide electronic data submissions and there is a citation with respect to private bidding for construction projects, and I know I'm oriented this towards the construction industry, but any perhaps business transaction where there's a bidding process, if you're asked about an OSHA citation of violation, you must answer affirmatively. You can explain what happened, but nonetheless, that's still going to be something that private owners can perhaps look to in terms of disqualifying certain bids or just declining to do business with people. Same goes for the public sphere. At one point during the Obama administration, there was a requirement that on any federal construction or federal procurement bidding, a disclosure of all OSHA-related violations or anything related to the Department of Labor that might be considered adverse. That was created by executive order. It was rescinded by an executive order of the Trump administration. But nonetheless, if asked by some of the questions that we saw earlier, whether it's in federal or any of the state public bidding, there is a required disclosure. If not, you can run the risk of both debarment and perhaps even criminal sanctions. As well, that's for failing to disclose. Once you do disclose the violation, or perhaps don't disclose fully, that can affect the determination of whether a business is a bidder is a responsible and responsive bidder. Responsive, in other words, the requirement to provide accurate information, and responsible having the capabilities and past performance to perform the project at hand. So, what do you do then? We missed the deadline. What do you do? Submit your data as soon as possible. As well, provide that letter to OSHA explaining why there was a failure to submit timely. I know that often pertains to technical problems, but it's not going to hurt to do that for any untimely submission. If for whatever reason, and so if you are dealing with an attempt to submit but a technical difficulty, do provide documentation of the proof of the attempted submission. And then for untimely submissions or where you miss the deadline, do provide those records, the written records, hard copy records if you have them. Turning finally to other consequences for missed deadlines, and this goes back to our theme of do or do not, there is no try. There is a great reason to make sure that you get this information submitted. Obviously, we talked about before that the consequences for a business's safety reputation, that as well can have effect on potential employers and recruitment, and therefore your business's workforce development. And then finally, or additionally, business development can also be affected by a missed deadline in that, again, OSHA citations, OSHA violations can be one of many criteria that businesses will look to in terms of whether they want to work with each other. As well, any violation or citation from OSHA is going to have an effect on insurance costs. Finally, taking a look at where all this is going, for those of you really interested in compliance and regulatory issues, we've had a new administration, an executive administration that has made a lot of deregulatory promises. I talked about the rescinding of the mandatory disclosure executive order. You can see that 300 and 301 data submission has been removed. However, there's also been, as much as there's been a scaling back or a walking back of certain enforcement, there's also been increased enforcement as well. We've got penalties for 2016 violations. Those were clearly spelled out. We now have through the SST what I like to call the naughty list, appropriate for perhaps this time of year. And you can see too that that SST memo is incorporating some of the enforcement for the 2016 penalties, 2016 data into 2017 data. So is there a pattern? Is there a regulatory shift? Hard to tell at this point. Looks like it's going in two different directions. I thank everyone for your participation and your interest in this topic. You can see that as much as the rule seems like a pretty clearly and well-structured rule, when it gets down to enforcement and penalties and sort of the other fine details of it, those issues can create some rather pointed and fact-specific questions. I'm happy to take questions now. I don't see any coming up so far, but certainly if anybody has any additional questions and wants to reach out, by all means, give me a call, shoot me an email. I'm happy to offer further input. You can see it's technical, you can see it's detailed. Personally, I find it interesting and fascinating. I'd be happy to help anybody out in terms of navigating through this process. I apologize for going a few minutes over, but I thank you all for your attention. And so with that, this closes our session. I hope you found it informative. The slides and the link will be circulated shortly, so just keep your eye out for that email. There will also be a link to the recording on the website. And thank you to everyone, and enjoy the rest of your day.